On November 23, 2020, U.S. District Judge Jeffrey S. White heard arguments focused on a single question. Did the Department of Homeland Security (DHS) and Department of Labor (DOL) have good cause to bypass standard rulemaking procedures and publish emergency regulations to restrict H-1B visas? The plaintiffs, businesses and universities led by the U.S. Chamber of Commerce, argued case law, economic data and the Trump administration's actions show good cause did not exist. The DOL rule took effect on October 8, 2020, and the DHS rule is effective December 7, 2020, unless blocked. The plaintiffs are asking the court to vacate both regulations. The Administrative Procedure Act (APA) requires federal agencies to provide notice and the opportunity to comment before a regulation goes into effect. The Trump administration published the DHS and DOL H-1B rules, interim final, and claimed, good cause, reasons existed that justified the agencies publishing the regulations and allowing them to go into effect before allowing the public to comment. This is the central dispute between businesses and universities and the Trump administration in U.S. Chamber of Commerce et al. v. DHS et al. Whether the economic situation created by the coronavirus pandemic provides DHS and DOL with a good cause exception for its actions. Paul Hughes of McDermott, Will & Emery, the lead counsel for plaintiffs in the Chamber lawsuit, emphasized the high stakes during the November 23 hearing. "We think this is an overt attempt to destroy the H-1B program," said Hughes, and several company executives and university leaders provided declarations to that effect. Zane Brown said, "Many of Amazon's most tenured employees, including data scientists and software engineers, would have to leave the United States." At the same time, Hughes cited the reliance issue for the University of Utah and its 350 H-1B visa holders, 5 hospitals and 12 clinics. The university's attorney said the DHS rule would cause substantial irreparable harm. Hughes also cited the Trump administration as a source. Ken Cuccinelli at the Department of Homeland Security said up to 200,000 H-1B professionals could lose their jobs under the rule. The Department of Labor estimated its rule, which inflates H-1B wage requirements by 40% or more, would cost employers $198 billion over 10 years, making it potentially the most expensive regulation imposed on businesses in modern U.S. history, based on an analysis by the U.S. Chamber of Commerce. During the court hearing, held via Zoom, the Trump administration did not offer strong responses to arguments plaintiffs put forward in their reply brief or in court. Below are the arguments central to the case. First, at the hearing, Paul Hughes noted that DHS and DOL rules failed to connect the H-1B visa category to the coronavirus-related economic problems.